Hey, so I wanted to talk about something today. So I want to thank everybody for tuning into my channel, and I appreciate getting uh the 3,000 followers or the 3,000 subscribers. My goal is to get to 6,000. Why not? If we can't, I'm hoping to get up to 6,000. But I appreciate the 3,000 subscribers for subscribing. Just like I say, I appreciate the positive comments and the not negative comments because each one of them helps me in some sense. So I'm going to talk about my fragrance today, which is Xerjoff Herba Puda. So we're going to get down to this myth of qualified immunity, and we're going to basically prove that state agencies do not have qualified immunity, and they do have qualified immunity, but we'll go over it. And in regards to lawsuits, in regards to the state suing its citizens, that's where they kind of create some type of hardship for them to be able to receive a claim, and this can be used against them in court. So I have to be very wary about the information I'm teaching people because it can be used for bad, and I'm not trying to do that. So I'm trying to teach people who are legitimately, good people who may be in some sort of, bind. Kind of give you a little something that you can use and bring up if you're going through something. So, with all that yammering and jibber jabber, let's get to it. So, first, you have to understand what qualified immunity is. So, I hear people, saying you're using Wikipedia, you're using all these other things to teach people, and you can't teach people law off Wikipedia. Yes, you can if you know how to read. Okay, I don't have to just stay on Wikipedia. This is what I use to show people stuff in a sense to make it easier for them, to figure it out and to know that they can go to this stuff on their own. Now, it's harder for me when I do publications because I don't always have the link to publications or I don't always know where it's at because sometimes if you click off that, you'll lose your place in the document. Some of those publications I'm reading are almost 800 pages, and I'm not doing all that just for somebody to get a link. Okay, now all the jibber jabber's done. So qualified immunity is the type of legal immunity that protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated a clearly established statutory or constitutional right. So that would mean if a agent of a state or a municipality abridged your rights and these rights are protected by the Constitution, remember that you don't have constitutional rights. Okay. The Constitution is there to preserve your rights against public entities, meaning corporations or state agencies, right? That's what the Constitution is there for. It's not your rights. Okay. You have to know your rights to assert your rights. Okay. Qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Okay, now you understand that qualified immunity does not give a police officer immunity, it does not give a judge immunity, it gives the judge immunity to carry out their duties. Now, let me give you an example. I don't have to read Pearson versus Callahan. Like a lot of times, I don't go into case law. You can do that on your own time because really, I mean, this case is not going to tell me something I don't know. You know what I'm saying? I already know procedure. Okay. So we're not going to go over the summary because, in my opinion, summaries are very uh, deceitful because you have to actually read what happened in the case. But I'm going to go back because I can probably bring this case up another time on another call. Okay, when determining whether a right was clearly established, courts consider whether a uh, a hypothetical reasonable official would have known that the defendant's conduct violated the plaintiff's rights. Courts conducting this analysis apply the case law that was enforced at the time of the alleged allegation, not the law in effect when the court considers the case. Usually, in a qualified immunity case, in qualified immunity cases, the plaintiff will first bring a suit under Civil Rights Act of 1871, Section 1983. Okay, so you guys thought that civil rights was what people were marching for in the 60s, and civil rights just has to do with you suing someone civilly. That's what it has to do. So all this stuff, it was against racism and Martin Luther King and all. Come on, man, get out of here with that bullshit. Okay, some people really actually need to know history. It's not against racism and shit. It's always classism. It's always a class of people trying to oppress another class of people. That's why people band up together, regardless of race. If you look at most of the high ups in your state, there are different races of people, different ethnic backgrounds, and they're trying to oppress the people who are impoverished. Why? Because they always need somebody to feed off of. Against a public official, the public official will then raise a qualified immunity defense that protects the official from all but clear incompetence of knowing violations of the law if the official acted in a reasonable but mistaken way. Okay, so this is why this is why I say things like plausible deniability. Like in my one video where I'm talking about the right to travel, I have people telling me that I don't know what I'm talking about and that I don't know the difference between a summons, a citation, etc. Well, this is where you call plausible deniability, because even when facts are provided to these people, they still want to keep arguing about something that I'm clearly outlining in the video. Okay, you have to understand people will use plausible deniability to just like think about it with a man or a woman that dates somebody, and everybody's telling them, hey, this person is bad, and you're telling them, you're like, look at all these red flags. These red flags are right here. They will use plausible deniability because it suits their reality. Okay, that's how most people are. A qualified immunity is not immune from having to pay money damages, but rather immunity from having to go through the cost of a trial at all. Okay, so they're saying, hey, you can do damages, you could do a fee schedule, you can do whatever. Okay, you can receive money, but we don't want to. We know we already violate people's rights. We don't want to jam up the court system. You see what I'm saying? So there's ways to go around this. And I've showed people how to get around filing lawsuits and still getting money out of state agencies. I hope that they use these methods that I taught them, but this is not something I really discuss in public. Accordingly, courts must resolve qualified immunity issues as early in the case as possible, preferably before discovery. Why? They're trying to get them to settle before all their dirty laundry gets aired out in court. Okay, qualified immunity only applies to suits against government officials as individuals, not suits against the government for damages caused by the government officials' actions. So you have to understand that if you're seeking damages, in some entity against some entity, they're trying to say, okay, like you almost have to go after the individual. Although qualified immunity is frequently appears in cases involving police officers, yeah, because that's who you're going to deal with it most. It also applies to other executive branch officials, while judges, prosecutors, legislatures, and some other government officials do not receive qualified immunity. Most are protected by other immune doctrines. Okay, so the judge is not protected by qualified immunity, but guess what? You're not in court with a judge. Yeah, so the qualified immunity is technically under the executive branch. So since the courts are administrative, they're set up under the executive branch. See the trick? But if you don't know civics, you won't see it. In Harlow versus Fitzgerald, the Supreme Court held that the federal government officials are entitled to qualified immunity. The court reasoned that the need to protect the officials who are required to exercise discretion and the related public interest in incurring the vigorous exercise of the official authority. Well, the reason why they're doing this, and this is why I say this about case law being BS, is because case law is there to deceive you. So when they're talking about this Harlow versus Fitzgerald case, they're not telling you that the case was heard, or probably the initial case was heard in an administrative court. So an administrative court is different than a judicial court. Okay. So I want y'all to know that. So when you're going in these courts, you're going into administrative courts. They're completely different than judicial courts. And that's why you don't understand why I do my videos in the context that I do them, where I'm telling you, hey, why are you arguing the right to travel? You're not even in a judicial court. Why are you arguing any law? You're not in a judicial court. So while with regard to certain government officials, including the president, prosecutors, and similar officials, the court upheld the absolute immunity only in certain functions. The doctrine shields those individuals from criminal prosecution and lawsuits as long as their actions in question were within the scope of their jobs. For federal, now remember, it's within the scope of their jobs. Okay, so if you're going to bring a claim, you need to understand the scope of the police officer's job. That's why I always tell you. That's why I say I always learn procedure, because if somebody steps out of their role procedurally, boom, I got them. So you can sit there and try to learn all this other magical stuff out of the redemption manual, but this is the stuff that I see works consistently. Okay. For all other federal officials, the court also held that federal officials who are trying to qualify for absolute immunity have the burden to prove that public policy requires an exemption of that scope. For government officials trying to qualify for absolute immunity, the court also established a two-part test that the official must satisfy. First, the official must show that their position responsibilities had such a sensitive function that it requires absolute immunity. Second, the official must demonstrate that they were discharging the protected function of the position while performing the actions in question. So, Malley versus Briggs. Okay, these cases you can read on your own time, or you can click on this, read it and have fun with it. Okay, don't just read the syllabus, read the whole case. And you'll find out that, just like I said, that most case law is BS. It is there to create deception, and it is there to further the agenda of the people who are, and who need it. Just if you don't believe me, just look up the Rooker-Feldman doctrine. Okay, the Rooker-Feldman doctrine should tell you all you need to know. That how a case can be misconstrued, how case laws can be used to block people from equity and law, etc. Okay, so look, the Supreme Court examined qualified immunity for police officers with regard to acting on the basis of a faulty warrant. Now, I'm going to tell you, after I read this, I'm going to show you, because I've already read this case before. The court held that qualified immunity does not apply to a police officer when the officer wrongfully arrests someone based on a warrant. If the officer, who could not reasonably believe that there was a probable cause for the warrant, reasonably is determined by the action that an objectively reasonable officer would take. Now, what people don't understand is when an officer is serving or delivering a warrant, where his qualified immunity comes in, he is taking basically the word of the court. Okay, so since he's taking the word of the court, he's immune from his actions because the court should have known. So the person, if he's delivering a warrant, who do you sue? You sue the person who issued the warrant, not the police delivering the warrant. Okay, this is why a lot of times y'all get in situations where you're suing the wrong people, you're escalating things to the wrong people, you're dealing with the wrong people, because you have to look at the action. Okay, in a court case is comprised of multiple actions, mainly two. One is the initial stop if you're in a traffic stop issues, which is a majority of cases, which is a traffic stop issue. And then the second is the court. Okay, if you understand that there's two separate actions going on, the same thing with child support. One is the child support agency's case number, and one is the court case. So they're two separate actions. Okay. So sometimes when you're suing the agency, you're suing them in the wrong capacity and you're suing them for the wrong thing. You see what I'm saying? So you have to understand the action that is a colorable offense or what robs you of your due process or whatever. Okay. In Anderson versus Creighton, the Supreme Court held that when an officer of the law, in this case an FBI officer, conducts a search which violates the Fourth Amendment, that officer is entitled to qualified immunity if the officer proves that a reasonable officer could have believed that the search constitutionally complied with the Fourth Amendment. Okay, that's a very hard thing for them to prove if you understand law. That is very hard. Shit. With me, I'd have, I'd have went wild on that one. The relevant question that a court should ask is whether a reasonable officer could have believed the warrantless search to be lawful, considering clearly established law and the information which the officer possessed. The Supreme Court also held subjective beliefs about the search are irrelevant. Okay. So, in Saucier versus Katz, the Supreme Court held that a ruling on qualified immunity defense must be made early in the trial's proceeding because qualified immunity is a defense to stand trial, not merely a defense from liability. See? What? It is a defense to stand trial, not a defense from liability. So you might bring up that they don't have qualified immunity. They might bring up they do have qualified immunity within their duties, but that doesn't discharge them from the liability of any violation or any injury. You see what I'm saying? So, like, when you understand law, the way I read is completely different than the way most people read because I understand more of the procedure base of the way things are, in context, the way things are said. Okay, it just takes a lot of reading and then kind of processing things to your own mind. Okay, when there is a summary judgment motion for qualified immunity, the court shall rule on the motion, even if a material issue of fact remains on the underlying claim. So they're ruling strictly on the qualified immunity. So if they grant him qualified immunity or her qualified immunity, that does not waive your ability to sue them for liability. Ding, ding, ding. That's why I always tell people, if you're going to sue the police, sue them criminally first, and then you can come back and sue them for damages, punitive damages later. Or you can put that as a clause in there, but that depends on what you want to. So the court also elaborated a two-part test for whether the government official is entitled to qualified immunity. First, a court must look at whether the facts indicate that a constitutional right has been violated. See, I don't argue anything about statutes or statutory law in regards to violation of the statute in its relation to the Constitution, because I know most statutes do not comply with the Constitution. But if you understand the procedure or the basis of it, it'll bring you back to the Constitution. Okay, if so, a court must then look at whether the right was clearly established at the time of the alleged conduct. Under the Saucier test, every time I hear that, I think about Tropic Thunder, where what's his name? Robert Downey Jr. is. I used to be a Saucier in San Antonio. Okay, qualified immunity applies unless the official's conduct violated such a right. Okay, so it's all about violation of rights. Okay, so some of you guys who I knew somebody we were talking about it. He sued some agents in my state, and I tried to help him, but sometimes when you try to help people and they think they know more than you, it's kind of hard to try to help that person. So I just let that person be on their own. So in Person versus Callahan, The Supreme Court held that the Saussure test is helpful. It does not need to be applied in qualified immunity claims. Rather, a trial court should have more discretion in whether it should apply Saussure. I hope I'm not butchering that. The court also held that an officer conducting a search is entitled to qualified immunity where clear established law does not show that the search violated the Fourth Amendment. Okay, so now we're going to Sanford versus Redding. So in Sanford versus Redding, Sanford Unified District number one versus Redding, the Supreme Court held that even when an individual's Fourth Amendment right to be safe from unreasonable search and seizure is violated, the person performing the search may still be immune under qualified immunity. Now, let me tell you why this exists, because a lot of people don't understand why it exists. Okay, if someone illegally searches you, you really haven't suffered an injury, but their actions may cause it to where you do suffer an injury, meaning liability, being sued in court. You see what I'm saying? So they gives them qualified immunity because their authority is they can search you. It ain't hurting you. It ain't hurting you, financially or physically to search you, because it's not like they could take your money from you. If they do take your money, they give you what? A voucher to get it back. So you're not being injured at any time. So that's why sometimes people need to understand when their rights are being violated by the police. In most instances, you're not suffering an injury. Even if a police officer gives you a traffic ticket, sues you, brings you into court, if you know what to do, you can go ahead and bill them for the liability of the event. Okay? If clearly established law does not show that the search violated the Fourth Amendment. However, this holding was in context of a school official conducting a search of students for illicit items. The Supreme Court has historically given more deference to searches performed on students while in school, so this holding is more narrow than previously qualified immunity decisions. Vega versus Takara, probably butchered that too. Takora, I think. The Supreme Court held that violating Miranda rights does not provide a basis for a subsection 1983 claim. Rather, the court asserted that Miranda imposed a set of prophylactic rules that only focused on disallowing the use of statements obtained in violation of those rules. Further, the court argued that expanding the Miranda rights beyond that would impose substantial costs in the judicial system. See, they're thinking about the judicial system. They're thinking about backlog, how many cases that people would really bring up against, officers of the court or officers, so-called officers, right? Okay, so we're gonna get into why a lot of this is. You have to understand that in most instances, these people waive their immunity. Okay, so a waiver of immunity definition and legal meaning. So this is from Black's Law, second edition. Okay, so voluntarily relinquished by a witness to his right to refuse to give evidence that may incriminate him. A waiver of the Fifth Amendment. Okay, so now we're going to go to qualified immunity, because I'm going to bring all this home for you. So this is a site that I use very often that you may want to use, which is the National Conference of State Legislatures. Okay, so this is where I usually get a lot of information from. And it's a very good site if you know where you're looking for and you're looking for certain sources. So the doctrine of qualified immunity protects state and local officials, including law enforcement officers, from individual liability unless the official violated a clearly established constitutional right. So the Constitution is there put to hold public officials so you don't have a totalitarian dictatorship. That's why you always have these so-called dictators up there trying to chop at the Constitution and change certain things. And some people pass laws just so, other people can come back later and amend things. Yeah, because it's basically people just trying to chip away at your rights and further their control. But the evolution of qualified immunity began in 1871 when Congress adopted 42 USC 1983. This makes which makes government employees and officials personally liable for what? Money damages. Okay? If they violate a person's federal constitution rights, state and local police officers may be sued under 1983 until the 1960s. A few 1983 lawsuits were successfully brought. Okay, so it took people a minute to figure it out. It took people just getting their rights just violated before they figured it out. Well, what do you think is happening now? So modern day people are now finding out how to discharge mortgages at a more of an alarming rate, how to discharge car loans at an alarming rate, and look how long it took us to do that. You see what I'm saying? So in 1967, the Supreme Court recognized qualified immunity as a defense to 1983 claims. In 1982, the Supreme Court adopted the current test for the doctrine. Qualified immunity is generally available if the law a government official violated isn't clearly established. So you have to understand this. So when you hear this saying that law enforcement and local officials, okay, qualified immunity is for the executive branch. Okay, it's not for the judicial branch. So you never get into a judicial court because the only court in your state is the Supreme Court. So you're almost never going to get there. You know what I'm saying? I'm not saying you can't, but I'm saying in most instances, you're not going to get there. They're going to shut it down before you get there. Okay. So if a qualified immunity applies, money damages aren't available even if the Constitution violation has occurred. If qualified immunity doesn't apply when the government employee or official technically is responsible for money damages, the government entity virtually always pays. What? The government entity virtually always pays. So qualified immunity protects states and local governments from having to pay money damages for actions not yet deemed unconstitutional by a court. So the qualified immunity doctrine is favorable to states and local governments. Clearly established means that at the time of the official's conduct, the law was sufficient, clear, that every reasonable official would understand that what he or she is doing is unconstitutional. So we all know it's unconstitutional to take people's property without just due compensation. We all know that it's unconstitutional to intimidate somebody. We all know it's unconstitutional to hem somebody up against their will without having a crime or any type of violation or any public endangerment. We all know that. So that's where your scope is narrowing down. Now they try to use gray areas and other things to protect them, but yeah, that is what it is. According to the Supreme Court, qualified immunity protects all except the plainly incompetent or those who knowingly violate the law. Okay, the Supreme Court has offered multiple justifications for qualified immunity, including that it encourages the government officials to unflinchingly discharge their duties without worrying about being sued for actions a court has not yet held violate the Constitution. All right. Okay, so look. So we'll get to, all right, so the Supreme Court has held that the use of force by a police officer and correctional officer violates the Fourth Amendment when it is excessive. Okay, so what constitutes as excessive? Okay, police and correctional officers receive qualified immunity if it isn't clearly established that the use of their force was excessive. According to the Supreme Court, while qualified immunity does not require a case directly on point, it does require that the existing precedent must have placed the statutory constitutional question beyond debate For example, in 2014, the Supreme Court held in Plumhoff versus Rickard that police officers didn't use excessive force in violation of the Fourth Amendment when they shot and killed the driver of a fleeing vehicle to end a dangerous car chase. Of course, they're not going to rule that in that because that is public endangerment. Okay. The court also held that even if the officer used excessive force, they were entitled to qualified immunity because it was clearly established that shooting the driver in these circumstances amounted to excessive force, which is a correct ruling. That's a correct ruling. Proposed federal legislation was put forward to modify or eliminate qualified immunity in 2020, but states also took action to address the legal liability of law officers for excessive force and other unlawful actions through state law. So, state law. Colorado was the first state to statutorily limit the use of qualified immunity as a defense. As I think they should start limiting the qualified immunity, I think they should limit it. But I do believe that police officers should be able to carry out their duties as well as administrative judges, etc., without having to worry about being sued every time. But yeah, if you violate somebody's rights or you violate their rights in court or whatever, yeah, you deserve to be sued. But you shouldn't be sued just because a verdict went against somebody. That I'm in favor of that. In defense in law enforcement cases at a state level. SB 217/2020 created a new civil action for deprivation of rights by law enforcement officers. Okay, this happens a lot in most cases, deprivation of rights, even in mortgage cases, in car repossession cases. There's a lot of deprivation of rights going on. Okay, so the law specifically states that qualified immunity is not a defense and limits the applicability of Colorado Governmental Immunity Act. Successfully, plaintiffs are entitled to reasonable attorney fees, and the jurisdiction employing the officer is required to indemnify its employee unless it determines the officer acted without a good faith and reasonable belief that his or her actions were lawful. Okay, so they're going off of intent because you're going to find out that most crimes or criminal rulings are based off intent, like fraud is based off intent. Okay, in that instance, the officer is personally liable for 5% of the judgment or 25,000, which is less. In the event, because that's probably what their bond max out at. Okay, in the event the officer is unable to pay, the jurisdiction is responsible for the entire judgment. Indemnification is not required if the officer is convicted of a crime arising from the same conduct. Connecticut, via HB 6004, also created a new state civil cause of action for people who seek recourse when an officer deprives them or a class of individuals of equal protection or privileges and immunities of state law. The law eliminates government immunity as a defense, but does not explicitly address qualified immunity in the same way that Colorado does. So we're going to get into one thing, right? We have to understand where the Supreme Court is coming from, right? So what the Supreme Court is coming from an aspect where they're just giving the executive officers the ability to carry out their job. So that's all they're doing. So we're going to get into something else, that some of these cases and these controversies that you guys are going through, I need you guys to understand, is sovereign immunity. Now, when I was talking to somebody and they're saying, I don't know what I'm talking about, etc., okay, they don't understand procedure. So if you don't understand court procedure, you don't understand what the state has to do to get you in court. That's why I went over Rule 19 on that, how to get rid of traffic cases, etc. Okay. If a state is suing you, right, or an agency is suing you, and they have so called sovereign immunity, if you read the 11th Amendment, right, it'll say, it'll specify on there, and we can go over there so you can see this too, because some of you guys don't read the Constitution. So, so we'll read it. So, the Constitution of the United States, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Now, we'll get to sovereign immunity. Okay. Now, if the state is going to claim that they have sovereign immunity, there's no way that they can beat me in court. Let me say that again. I want for all you people who follow these, who are trolling, and for some of y'all who are not trolling, whatever. If the state is going to act immune from actions, they cannot win in a court case. They can't. And I'm going to show you why. I'm not going to go into it that deep, but we're going to go into sovereign immunity. First, you have to understand what sovereign immunity is. And the reason why I read this, even though people say Wikipedia can't teach, you can't learn law of Wikipedia. I don't learn law of Wikipedia. I just use it to make it simple. Okay. Look, Wikipedia. Okay. So we'll go over it. Not to be confused with the doctrine of state immunity. So the doctrine of state, the doctrine and rules of state immunity concerns the protection which a state is given from being sued in the courts of other states. The rules relate to legal proceedings in the courts of another state, not in the state's own courts. The rules developed at the time when, I'm going to click on here. The rules developed at the time when it was thought to be an infringement of the state's sovereignty to bring proceedings against it or its officials, its officials in a foreign country. There is now a trend in various states towards substantial exceptions to the rule of immunity. In particular, a state can be sued when the dispute arises from a commercial transaction entered into by a state or some other non-sovereign activity of a state. The United Nations Convention on Jurisdictional Immunities of State and Their Property, which as of 2015 is not in force, would reformulate and harmonize these rules and their exceptions. It does not cover criminal proceedings, and it does not allow civil financial actions for human rights abuses against state agents where the abuse has occurred in another country. All right. So you have to understand Article 3 of the United States Constitution. Okay. So you have to understand if a state is acting immune or acting as if it is immune, then you have to understand that it cannot get judgment against you. Okay. So Article 3 of the United States Constitution provides that federal courts have jurisdiction over cases and controversies arising under federal law. And construing these terms, the United States Supreme Court has held that a plaintiff must establish standing to bring a lawsuit in federal court. That is, the suit must be based on actual or imminent alleged injury that is concrete and particularized. So let's get to it. So if you're dealing with the state agency, right? If the state agency is suing you, the state agency must prove an injury. I know that some people think that the state can sue you because they pass their own laws and they pass their own they pass their own laws and their own policy, yes, they can fine you. That has to deal with capacity to sue, but that does not deal with standing to sue. So for a state to sue you and to obtain a judgment that is enforceable in law, they must have standing to sue. So let's look up what standing to sue is. Sorry, it's taking a little while. Okay. So, derived from the Latin term locus standi, standing to sue is a broad concept that means the person filing a lawsuit against another party must be the proper party to request adjudication and compensation. In simpler terms, no, I don't need your help. In simpler terms, people can't simply sue each other for no reason. You have to have standing to file a lawsuit for it to be valid in the eyes of the court. To determine whether a person has standing to sue another party, another individual or party, a lawsuit must contain three key elements. So, what are the three elements of standing to sue? When filing a lawsuit, you must prove that you have all three elements of standing to sue, not just one or two. Injury in fact. The first and arguably most important element is injury in fact. So if a state agency or a municipality pulls you over, what is their injury in fact? They don't have it. So when somebody is telling me that I don't understand the law, you might want to look in a law book and understand that you don't understand the law. When you violate an ordinance, there has to be an injury. That's why they give you the traffic ticket. The traffic ticket is your basically get out of that ticket entity. When you know how to transfer your interest, or when you know how to endorse a traffic ticket, you can settle an obligation. Okay? So it's not a liability instrument, it is an asset. Okay? That's why they're giving you an asset, because they don't have an injury in fact. But they can default you from performing an obligation. Okay? So I'm sorry for you guys who don't understand law. I'm sorry for you guys who cannot see through this matrix, but I'm trying to bring it to those who can. Okay? The whole game is basically they have to create an injury or they have to create a performance. And they're suing you on the performance. So they're saying you owe us this amount of time and you have 30 days to appear in court. That's a performance. Okay, they're not suing you because you were speeding, driving under the influence, you had marijuana. They're not suing you for that. They're suing you for the performance on the ticket. Okay, this means that the person filing a lawsuit has to have suffered an actual injury. Note that an injury in the sense can include physical injuries, mental or emotional distress, or an economic loss. So if an attorney helps you if an attorney steals your car, they steal your house, you need to sue that attorney and all of the agents involved for an economic loss. Do you hear me? Additionally, an injury in fact can include harm caused to recreational, conservation, or aesthetic interest, depending on the circumstance and topic of the lawsuit. The injury must have occurred already in a majority of cases. That's why some of you guys bring up defenses in foreclosure cases. That's why you lose, because you're talking about an event that did not take place. It usually can't be something that may happen in the future. See? Listen to what I just said. It can't be something that's about to happen in the future. So if the bank is suing you on a default, you still have a maturity date of 30 years. And y'all losing y'all house? Stop it. You guys need to study law, man. I can't teach you everything. Some people want me to just and how would I do in this situation? How would I do? That is for private classes. It's not for public. It's basically telling you, you guys need to read more. Okay, when you're going through situations, you'll figure it out once you start reading more. Okay, here are a few examples of an injury in fact. You were driving through town and you started to enter an intersection. When the light turned green, a car barreled through the intersection directly in your path. The driver of the vehicle had a red light. You saw the driver running the red light in your peripheral vision just a second or two before you would have crashed. You slammed on the brakes and narrowly averted what would have been a horrific T-bone crash with your door being the point of impact. You were terrified by the experience and you suffered no physical injuries. Your situation does not satisfy the element of injury in fact. Same scenario, except you can't react in the time to prevent the collision. You suffer physical injuries from the collision. The situation does satisfy the element of injury in fact. Okay? So look, the original scenario, except you managed to avoid the crash, the extreme stress of the mere miss causes you to have a heart attack. The heart attack is your physical injury, which suffices the requirements of an injury in fact. Sometimes the harm is not to the person, but to your property. For example, you discovered that a nearby factory dumped toxic chemicals on your land. Damage to the environment can qualify as an injury in fact. Now you have to have causation. So if most people are teaching you on the internet the 5456s and 1099 OIDs and all this other bullshit, and they're not teaching you actually causation and injuries in fact, how the hell do you expect to win in court? Okay, causation. The next element of standing to sue is causation. This means that the injury a lawsuit revolves around must have been caused by the defendant party. In other words, if you are in a car accident, you cannot sue the at fault driving sibling to acquire compensation for your injuries or property damage. The at fault driver might not have insurance or sufficient personal assets to pay your losses, and they might have a wealthy relative. Nonetheless, merely being related by blood or marriage does not make the wealthy person responsible for the actions of their relatives. For a lawsuit to be successful, the plaintiff must prove a connection between the conduct of the defendant and the injuries sustained. Okay? Listen to what I just said. For a lawsuit to be successful, child support. What do you say? Child support. Um, for a lawsuit to be successful, the plaintiff must prove a connection between the conduct of the defendants and the injury sustained. Let's say that you were in a mere multi-vehicle car accident. You find out that one of the drivers got cited for drunk driving, but they were not the party to the collision, the party who caused the collision. They were negligent, but their negligence did not cause the crash. You only have standing to sue the party who caused the accident through negligence. Well, if an attorney steals my house or an attorney firm steals my house, who should I be suing? Should I sue the bank? No, I should sue the attorney's firm. Why? Because the attorney's firm is the one who caused the loss. I could add the bank as a party, but I should be suing the attorney's firm. Causation is the only one element you would have to have to prove to hold the defendant liable for your injuries and losses. Even if your lawsuit survives the challenge based on the standing to sue, your case could get dismissed if you cannot prove all four of these things. The defendant owed you a legal duty of care. For example, everyone who drives in California, the rules may obey our state's traffic laws. So, like if an attorney conduct business in the state, they must follow the state's laws. Okay, so the attorneys are supposed to know the state laws. The defendant breached their duty of care when a person fails to act in a manner that measures up to the legal standard. They are negligent. Let's say that the defendant was speeding, exceeding the posted speed limit, or driving too fast for the conditions is negligence. The negligence must be the thing that caused the accident that harmed you. If the driver lost control of their car because of excessive speed and skidded into your vehicle, as a result, their careless behavior caused the crash. You must have quantifiable losses, physical injuries to satisfy the requirement of liability. Okay, redressability. I love this one. Okay, lastly, your suit must have redressability. For you to have the standing to sue, redressability means that the court will be able to do something to make up for or correct injuries of the plaintiff. This can be financial compensation, the court orders that dictate the behavior of the defendant in the future, and so on. The court does not want to spend its time and resources on a case for which there is nothing it can do. For example, if someone breaks the law that does not provide consequences for violations, the court will likely say that the plaintiff has no standing to sue because of lack of redressability. So, I hope you guys learned something today about qualified immunity and how to bring a case. Okay, I'm basically teaching you how to bring a case little by little. You're going to learn this law stuff. We're going to put it together. And I got a new law class coming up. I know the 4-1 was pretty good, but the new one is going to be it's going to be a monster. I want to thank everybody who's got me to 3,000 subscribers. And let's see if we can go to 6K subscribers. I appreciate you all. Have a good day.